Hi, I'm Mark Skaist, corporate partner with the law firm Strading, Yocca, Carlson&Rauth in Newport Beach, California. We all know that identifying potential investors and getting them to invest in your startup venture is extremely difficult. So many entrepreneurs engage finders to help them identify potential investors. I'm going to discuss a few potential legal pitfalls that you should make sure to avoid when you're out there working with finders and shaking the money tree. Failing to avoid these pitfalls could jeopardize your ability to raise additional money in the future and could result in potential legal exposure for you and your venture. The use of finders is fairly common. However, there are potential issues when using a finder in cases where the finder is engaged in activities that require them to be licensed as a broker-dealer. If you use a finder, and if that finder is considered to be acting as a broker-dealer and is not licensed as a broker-dealer, there are a number of potential negative consequences to the company raising money. First of all, some states, including California, give the investors in the offering the right of rescission, which means the right to get the money back. Also, you should know, whenever you raise money, you should make sure that you have an exemption from the applicable state and federal securities laws, and the use of an unlicensed broker-dealer could very well affect your ability to fit in one of those exemptions, which could result in rescission rights, and which could also affect future offerings as well. So the question as to whether or not a finder is really acting as a broker-dealer is a factual one. The general consensus is that finders can really do nothing more than provide potential names and telephone numbers of potential investors. When they do more, such as providing any advice or recommendations regarding the investment, conducting due diligence on behalf of the investors, handling the investors' funds, or being involved in any meetings or presentations with the investors, there's a good chance they're no longer just a finder. Another potential factor is the way the finder gets paid. Some attorneys and commentators suggest that it's a problem if the finder gets paid a success-based fee. In other words, a commission which is a percentage of the amounts raised. There's no legal authority to suggest that a percentage-based success fee is in and of itself enough to cause a problem. But the safest thing to do is to pay a finder a flat fee, such as a monthly retainer or an hourly rate, which is not tied to the amount of money the finder helps them raise, especially when the finder is in communication with the investors regarding the investment opportunity. Now, for many startups, paying a monthly retainer isn't always an option, and oftentimes I'll recommend that my clients not sign up to an arrangement like that, since the finder's compensation should be success-based to ensure that the finder is sufficiently motivated to help raise money instead of just collecting a monthly retainer. So more often than not, these types of relationships are structured so the finder will get a commission only if an investment is made in the company by an investor identified by the finder. Again, there isn't any hard and fast rule prohibiting these types of arrangements, but it's certainly safest to have the payment be a flat fee, not tied to a percentage of the amounts raised, especially if there is some concern about whether or not the finder is doing more than just handing the company a list of names of potential investors. It's also important to have in the agreement with the finder language where the finder agrees to do nothing more than just pass along the contact information. Also, have the finder agree that it is not required to be licensed as a broker-dealer and that it will bear any responsibility or liability if it is determined that they were in fact acting as a broker. What this does is, at a minimum, shift some of the legal burden to the finder if the finder acts as a broker and isn't licensed to do so. If the finder is really acting as a broker, then the company will still have potential legal exposure, but by having the finder agree that he or she won't be acting as a broker, well then at least there may be some legal recourse against the finder if there's ever an issue. Even with this type of language in the finder's agreement, the safest route is to still ensure that the finder doesn't do more than just pass along the names of potential investors, since having to rely on suing the finder if there ever is a problem isn't really an attractive alternative. One other potential option in cases where the finder is likely going to be doing more than just furnishing the names of potential investors is to have the finder affiliate itself with a registered broker-dealer for purposes of the engagement. That way, the company can work with the finder through a registered broker-dealer, in which case the finder agreement should be entered into directly with the broker-dealer, and the broker can have a separate agreement with the finder regarding the finder's compensation. One practical issue to be aware of is that using finders might not be appropriate in all types of financings. For example, VCs and other institutional investors, even angel groups, oftentimes don't want to see a portion of their investment going to pay a finder, so they oftentimes won't invest in a startup where the finders are involved. They would rather be introduced to companies through the company's advisors, such as accountants and attorneys. So using finders seems to make sense as a startup when companies are looking to raise money from a number of high net worth individuals who are part of the finder's network. Some of the things to take away from what I just spoke about are, if you're working with a finder, you want to make sure that the finder, if they're not registered as a broker-dealer, is really doing nothing more than passing along the names and the contact information of potential investors. You'll also want to make sure that you try to pay the finder a flat fee if at all possible, and if you do pay a success-based fee based on the amounts raised, make sure that the finder is doing nothing more than just passing along those names, and make sure you have a written agreement with the finder which shifts some of the responsibility to the finder to make sure that they're not acting as a broker-dealer when they're not licensed to do so. We at StradingYoccaCarlson&Rauth are proud to have a working relationship with TriTech, which is a terrific resource for emerging companies and entrepreneurs. You can reach me at mskaist@sycr.com. Again, my name is Mark Skaist, corporate partner with the law firm StradingYoccaCarlson&Rauth in Newport Beach, California.